VIP. If VIP was being expected and there were more than 500 Ndaba within and outside that airport, and I was asking question.
Are they private protection guards or what?
You can't really tell. They are not branded. This is a federal institution, an airport, a federal airport, for example. And beyond that, Okiria, I was thinking about, can the government withdraw all the policemen attached to traditional rulers, local government chairmen, businessmen, like the
but have they not done that? Have they not announced it several times?
You still have pockets, even National Assembly members. Put them around parameters in the country instead of guarding individuals,
all right,
and you see magic happening.
Why we are not able to stop talking about this is because as we speak, communities, people, and I have told you that I have contributed money 3 times for people who were kidnapped. I'm not telling you stories. People are contributing money. People are free to pass through the road, and our brothers, our sisters, our babies are in detention, in the abduction camps. And I don't think it is fair for us to begin to talk politics every day without reminding the government that they have a duty. That is why we are on top of it. And for as long as there are no new measures, things that can excite us for us to take actions, then we'll continue to mention them. The much we can do is to let the government know that they are failing those citizens who are in camp, in abduction camp currently. Those who cannot pass through the roads, they pass through the roads. There are National Assembly members, when they do pass through the road, they are escorted. We have a lot of protection for our government officials. Where is the protection for the citizens? Now, when we come back, we go into politics and begin to discuss the decision by the Federal High Court yesterday. Like I told you, we have a lineup of guests. We also have one in the studio. Samson Todo of YIAGA Africa will tell us how it may impact the ongoing process of elections. And the lawyer who was also in court yesterday will tell us how they managed to get that order for the Youth Party. One of the parties that many people are not aware even existed. It's one of the 21 political parties. If you go to Google, they will give you the list of the political parties. And then we have Nicholas Osai in the studio, a former member of the House of Representatives. He's likely to be glad to tell us if his colleagues himself within the APC, how they receive it, and whether it is going to cause some movement, some implosion, some people will say, within the party. Let's take a break. We'll be back shortly with the lineup of our interviews. Don't go away.
Chambers where laws are forged and a nation's destiny is decided.
This is your parliamentary program, Inside the Parliament on AIT.
Voices rise, opinions clash, debates ignite.
We cannot be apologetic in the discharge of our constitutional duties as lawmakers of the Federal Republic of Nigeria.
The burden of proving that the election peacefully and in accordance with law must shift to INEC.
From the Senate to the House of Representatives, this is where policies are tested, laws are crafted, and authority is held to account.
We spoke to some lawmakers on their opinions of the document presented by the President.
Every motion, every argument carries the hopes of millions.
We need more hospitals, more health clinics in communities so that they can effectively take care of the primary health need of people.
The questions are tough. The exchanges are intense.
Mr. President, you can have your way, but I will have my say. You can use the gavel, and I will use my voice.
And those who want the proviso are 55 in number. And so the proviso says.
But who truly stands for the people? Who is driving the change that defines our tomorrow?
GTBT, whatever.
Get the answers on Where Nigeria Decides on Inside the Parliament on AIT every Tuesday, 4:30 p.m.
While we are waiting to have our guests on the video wall, that is those who we're going to take on Zoom, then we'll come to the issue of at hand. Let me just give you a rundown. The timeline set by the Independent National Electoral Commission, INEC, for political parties to carry out activities ahead of the 2027 elections came under hammer of the Federal High Court yesterday in Abuja. The court held that, one, INEC can only monitor political parties and cannot dictate when political parties must conduct their primaries for the 2027 elections. 2, INEC cannot shorten the timeline within which political parties are required to submit candidates' particulars. 3, INEC cannot impose a shorter deadline for the withdrawal or replacement of candidates, including placeholders arrangements. And 4, INEC cannot publish the names of list of candidates earlier than 60 days before the elections, in line with the provisions of the Electoral Act. And 5, INEC cannot compel political parties to end campaigns 2 days before the polls. A very, very, very straight, when you talk about watershed on all that INEC has planned out. And I will tell you the background. The background is that the electoral law and the constitution, the constitution is the ground norm, as the lawyers to put it. If the electoral act says, if the constitution says we have the right to associate, freedom of association, nobody can come and say, even an act of the National Assembly cannot remove that right from citizens. It means they cannot tell us to associate at a particular period and not to associate at a particular period. We will need to go back to the constitution to change it if that is what we want. But for as long as the constitution says freedom of association is the inalienable right of citizens, INEC, even the Electoral Act itself cannot say it is one that they can abridge and decide when we can associate and when we cannot associate. The second point is that the Electoral Act set up timelines by it themselves. They stated there are specific timelines Electoral Act have mentioned. If there are areas they didn't mention, INEC can play around it. But where they specifically said 60 days, 90 days, the Independent National Electoral Commission does not have the right to go and abridge it, amend it without going back to the National Assembly. That was the case they took. Some persons have asked me, can they appeal it? I said, yes, they have a right to appeal. But how would they go around it with the very learned judges at the Court of Appeal over this matter? Except, of course, Nigeria, it is possible. Uzodimma became governor of Imo State. He came fourth in the election, except the judgment is written for them. I don't know if that is possible in Nigeria. Has it been possible? I'm not the one to say it. But let's begin with the guest in the studio. We also already have one of the lawyers that handled the matter in court on Zoom. But let's begin from my guest in the studio, Nicholas Osai. Honorable, thank you for joining us on the program today.
Yeah, thank you.
Now, let's just go straight to it. How did you read the judgment? How did you see the judgment? How did you see it yesterday when it came to you?
Yeah, thank you. Before the judgment, let me also make comments on the security. I think government is doing its best. Last week, we heard about success story, what happened in Borno State. I think that is the reason why National Assembly is pushing for state security. I think state police. So I think that can be able to protect the citizens when that is done. On looking at the Federal High Court yesterday, judgment based on the Electoral Act. Electoral Act derives its power from the Constitution, which is the parent law. And INEC has a duty to put a timetable based on the Electoral Act that created it. So I feel that
that's guided properly.
That's what I'm saying.
By the Electoral Act.
By the Electoral Act. If Electoral Act has fixed a specific date, upon which INEC has to derive its power, to be able to put that timetable. And if INEC has gone wrong, and people have a right to interrogate such law, and they have done that in the legal finance of our country. And the learned judge, that is the presiding judge, have given his judgment based on the Electoral Act. I think Nigerians, politicians should follow the way, because that is the law today. The Federal High Court judgment is the law today. It's the law today, until it is set aside. Until it is set aside.
Here, when a law is enacted and when you put in politics behind it, it becomes a problem. When you also interpret and implement implement a law and you're guided by political consideration, it becomes a problem. Now, what the court has said is that INEC, you erred in setting this timeline. Look at what the Electoral Act says. You cannot be anything below September. And this is not the only case that is in court or was in court challenging this case challenged the electoral guideline introduced by INEC flowing from the Electoral Act. There's another case instituted by NDC, Barrister Vincent Otobo, who is prosecuting it, challenging certain provisions of the Electoral Act 2026, saying that there are several areas where it conflicts with the Constitution. For instance, they talked about the Electoral Act remove educational qualification as a means of challenging the outcome of an election in a pre-election case. But the lawyer is saying in the Constitution, it was clearly stated that you must be qualified. So for an Electoral Act to override the Constitution, it becomes a problem. So that's the question before the High Court to determine. And don't be surprised if when judgment comes, it strikes down certain provisions. Not just that, some other areas of the Electoral Act.
I agree with you completely because, you see, when you are making a law, you must look at the Constitution. If Constitution have mentions on certain qualification criteria,
you cannot change it.
You cannot change it. And that also brings me to issues between the Electoral Act and the Constitution of APC. The Electoral Act in Section 86 empowers the APC to create its own constitution and to use it in direct primaries. Now, in Article 20, subs 4.1 of the APC constitution, it is guided that all card-carrying members the party ought to vote.
Okay.
And in voting,
don't miss the point. We'll take you back to this point. But let's go to Marcel Egbinine. Marcel Egbinine is one of the lawyers that prosecuted this case yesterday. Got the case prosecuted up to the judgment yesterday in court. I hope we have him on the line now. Thank you for joining us this morning on the program, Marcel. How did it go yesterday? How did you quietly manage to get this judgment from the court along with your team leaders?
Okay, good morning. I can barely hear you. I'm really struggling to hear you.
Okay, can you hear me now?
Yeah, it's a tiny bit better.
Okay,
yeah.
I was asking, how did you manage to come quietly with this case along with your team leaders to get this matter to the judgment yesterday?
Okay, the judgment was actually delivered 2 days ago, not yesterday.
Okay, go ahead.
Yes, it was delivered 2 days ago, and like my other guest was saying, we challenge the position of INEC as it relates to the Electoral Act. So it didn't gather enough. Media attention just because people did not really appreciate what we were doing or what our case was at that particular time. So it's after the judgment that people began to appreciate what we meant by that authority, by those cases.
I know you are at the airport and waiting to catch your flight. But what are you awaiting? How are you awaiting? What do you call it now? An appeal in this matter. Definitely, the Independent National Electoral Commission may want to appeal this matter. How are you waiting for the appeal?
So, Marcel, can you hear me? Can you hear me, Marcel?
Yes, I can hear you now.
Okay,
so
what do you expect to happen now after this judgment has come? What are your expectations from INEC and from the political parties?
Do you expect an appeal?
Well, I do not expect them to appeal because this is not the first time that the Court of Appeal will be making a decision like this. Earlier on, during the last election cycle, a case between INEC against PDP, the Court of Appeal stated that INEC does not have the power to give any regulation that contravenes the provision of the Electoral Act. So I do not expect them to go back to the Court of Appeal, when this Court of Appeal judgment is still subsisting. INEC has stated clearly, you do not have the power to give any decision that contravenes the provisions of the Electoral Act. So I do not expect them to go to court.
It's all right. Let us allow you to wait for your flight as you go. I thank you for squeezing out time to talk to us and at least putting the face to the judgment in court yesterday. Thank you so much, Marcel, for talking to us on this matter. Now, we have
Samson
Itodo. Samson Itodo, my good friend, is the executive director of YIAGA Africa, a civil society organization that promotes democracy, and they have taken particular interest in this election and the processes. Thank you so much for joining us on the program, Samson.
Thank you very much, Chief Ohere. I wish you could be a lot more audible, because there's something fundamentally wrong with the audio.
Okay, let's go straight to the issue. Let's go straight to the issue at hand. Let's take a look at what happened at the court yesterday. How did you receive that judgment as an organization that has been campaigning for fairness, for strict rules application, and for every institution saddled with the responsibility of conducting elections to stay by the rules? How did you receive this yesterday?
Well, this is a democracy, and in a democracy, when political actors feel that their interest and their rights are being infringed upon, they have every right to seek legal redress through the court. And so the fact that, a political party decided to ventilate its grievance through the court, I think it's a welcome development. But we must also stress that judicial review or scrutiny of administrative actions, in other words, actions by institutions of state, it's a legitimate feature of any constitutional democracy, and it's not a threat. Now, you see, we have constantly raised concerns about compressed timelines introduced into the Act by last-minute amendments introduced by the National Assembly. Now, if you check some of those amendments that were introduced at the dying minute, they shrunk the political space, disadvantaged some political actors, and then imposed logistical challenges on INEC. And we made this point consistently. So when you look at the combined effect of a late passage of the Electoral Act, coupled with, difficult timelines introduced by the National Assembly, a difficult environment was already created. But that environment that was created required some careful judgment and broad stakeholder engagement by institutions like INEC. So when you look at the judgment, quite frankly, the judgment is legally sound, but to an extent, it is narrow in scope. And that's the position of YIAGA Africa. The judgment reaffirms a fundamental constitutional principle that all institutions, including INEC, must act within the law, and that subsidiary instruments such as regulations or guidelines or timetables cannot override or supplant or substitute statutory enactments. And if you check the position of the Supreme Court, it's very, very clear. When you look at the Act, the 2026 Act was very clear that submission of list of candidates must be effected not later than 120 days before the date of an election. Now, it says not later than. Yes, not later than. But the Act does not expressly forbid early submission. So when you look at the plain reading of the Act, it sets a deadline, but it does not prohibit early submission. Now, what this suggests is that INEC can, with its administrative discretion imposed on it by the Constitution, ensure that it sequences electoral activities. And the reason for that is that there are multiple legal and procedural steps that must be completed before candidate nomination. For instance, yes, the primaries must be conducted, but the Act also says that 21 days after INEC has submitted the forms of candidates, it needs to publish their particulars. But listen, despite, this legal interpretation, I think the bigger issue here is sound judgment. And I think INEC may not have erred in law based on some of the rulings, except for one that relates to the timelines for campaigns. But INEC's discretion, should expand the democratic space and not restrict it. So given late passage of Electoral Act, compressed timelines, and coupled with the fact that the initial timetable was already reviewed due to religious observances, there was a strong case for INEC to express and provide greater flexibility to allow political parties enough time, to organize credible primaries. Unfortunately, it didn't do that.
In the current electoral process?
I think the judgment is, as of today, the ruling is very clear. The implication is it will extend the time for primaries, except if INEC takes steps to either file for an appeal, or it complies with the judgment, or further review of the timetable. And my principled position is that in view of the fact that, one, the Act was passed late, you had reviewed the timetable due to religious observances, and there were compressed statutory timelines, that more space would have been given to the political parties to conduct their primaries. This tight time frame really shrinks the political space.
How does it affect the confidence and trust Nigerians have on INEC?
I think it will in a great deal. And this is not the first time the parties have been screaming that they are suffocating because of these timelines. And I thought that reason could have prevailed ab initio in discussing with political parties to look at what timelines, can be provided. The truth is, there are decided cases in the Court of Appeal that once a statutory provision does not provide a bandwidth, in other words, what the law says is not later than, and it does not say, and it does not provide earlier dates. Therefore, INEC, in expressing its discretion, it needs to consider a lot of factors. You cannot have the National Assembly pass laws late, and then you have compressed timelines, and you have revised the timetable due to religious observances. All of these factors collectively creates a tight environment. So what INEC should have done was to extend the time and not compress the time, because make it difficult, for political parties to thrive. And so it would
Samson talked about tight
on the part of political actors.
Samson, you talked about tight schedule, and I'm thinking now it's already tight. You mentioned rightly, Electoral Act came late. Electoral guidelines has to be revised in terms of scheduling of the elections because of festival and religious consideration. Now there's a court judgment, and now INEC may appeal. It introduces some confusion for political parties. Which one should guide us? The judgment now, which has become law of the Electoral Act, or of the guidelines, or when INEC appeals, it brings in some uncertainty. I want you to speak to the uncertainty that this will bring in. But beyond that, my second question as a lawyer, there are some people, some opinion are saying this judgment opens the window for politicians to defect from one party to the other. That's for those that have not conducted their primaries.
Or those who are disgruntled and are not happy what happened in their parties, they can move to other parties now. Can you speak to that?
Now, so in terms of where the options before INEC, if INEC files for appeal and it doesn't file for a stay of execution order, if it applies for a stay of execution order and that order is granted, then status quo remains. In other words, the current timetable remains effective until that particular order is vacated. But we are now in the realm of, I would say, speculations, and we're being quite preemptive. But if INEC files for an appeal, then depending on the sort of pleas it provides to the court, and depending on the ruling of the court, we may just have to wait until this matter is dispensed with. And I hope that it will be given the sort of urgent attention that it deserves. But as of today, that window has been open because the court has ruled in this particular regard. So it will create the room for parties, to move. It creates a lot of confusion. And my point is, the actual problem emanated from the Electoral Act. It emanated from the same lawmakers, who are screaming today that the Electoral Act or their parties have shortchanged them when they had the opportunity to make laws for effective management of our elections. They prioritize their own parochial, their own political interest over and above public interest. And what is happening today is we need to put it at the doorsteps of those who actually made the law. But also, INEC is complicit.
The second question.
INEC is complicit.
The second question.
Because even though that this particular law makes the timelines very compressed, they would have taken stakeholders into confidence and considered all the issues, on their merit, but not create stiff timelines that make it difficult for whether they are opposition parties or smaller parties to thrive.
I only thought we should be fair to the Independent National Electoral Commission. The question I want to ask, just because the second question you still hanging, you have not addressed it because you were spending time on the first question. The second question was, do you think it's a window for political parties, members of political parties now to jump and say, look, thank God the windows are open. I was not happy with what happened in the elections. I want to go to another party. Pending when there is an order of stay or an appeal and the judgment is this a window from yesterday? Is there a window that politicians can take advantage of? Is this a window? And secondly, I want also, let us be fair to INEC. INEC came up with these guidelines because of they wanted to create a space for them to be able to print ballot papers. They want to be able to do all the printings and everything. They want to be able to have the time to do all that they needed to do. The logistics that you talked about initially. Is it going to put INEC in a very tight corner?
INEC was already in a tight corner, but to the first question, I did respond to it previously that this particular judgment has thrown the gates open for all forms of whether you call them cross-carpeting or decamping or people joining political parties. It's created that room. Unless a stay of execution order is granted by the court or an appeal is filed and is dispensed of timeously, the space is open as of today. So we just have to wait because time is of essence. I think on the second point, the big question, and I've made the point, is that INEC was already under pressure by the timelines introduced by the Electoral Act. Now, why INEC is issued a timetable with early commencement of primaries, I mentioned previously, was because before the 120 days time frame, there are several activities that must be performed and must be fulfilled by political parties. And therefore, INEC introduced this time frame. But the question is that in the light of the factors that I have identified, one, late passage of the Electoral Act, late release of the regulations and guidelines for the conduct of party primaries, the fact that the timetable has already been revised due to religious observances, what I expected was that INEC will sit with political parties and look at what time frames. Don't forget, a few weeks ago, INEC had to reverse itself on its position regarding the timelines for the submission of party members register, because the law is very clear that the registers of members shall be submitted to INEC 21 days before the date of a primary. So INEC cannot set, the date for the submission of the list of candidates. It is the prerogative of the parties. So if a party chooses to conduct its primaries on the 30th of May,
it is their right.
Counting backwards from the 30th of May, right?
All right.
INEC had to extend that time frame because INEC, as an election management body, deals with stakeholders. So it needed to consider this.
All right.
And look at this time frame. There was nothing wrong
with
having primaries extended to June.
All right.
We would still be within the ambits of the timelines created by law.
We must appreciate you,
Samson. Feel that they are being suffocated and they have a legitimate cause.
All right, we must thank you, Mr. Samson Itodo, Executive Director of YIAGA Africa. We must thank you for this analysis you have provided for us, the background and the challenges that behoves INEC now, and the expectations from the judiciary and what is expected on the field from the politicians and the political parties. Thank you so much for joining us and for doing this. And we want to...
Thanks, always a delight. Thank you.
Yeah. Let's take a break, and when we come back, our guest is in the studio, and we still have your mails waiting to be taken, and then we wrap up. Don't go away. You are on Political Platform.
TerraCube, unwrap joy, unleash taste.
Remaining with us on Political Platform, and you have heard it from people who are on the field. And in fact, even our guests in the studio agree substantially with some of the upside down that this probably will cause. Let us do some practical anticipation. Is Fubara going to move to another party now that the window is open? Will Yamu now say, look, I was shortchanged? Will
Nicholas Osai who said, have contested and they pushed me out. Do I move to another party?
Said he has been pushed out.
So let's come back to you. How do you anticipate that what we saw now, just yesterday as it came out, although the order was given 3 days ago, is going to be affecting the minds of the politicians who were complaining that the processes in their primaries were not correct?
Yeah, I think it will if the party do not do what is right. Most importantly, like my own case, the Article 20 sub 4.1 of the APC Constitution, which aligns with Section 86 of the Electoral Act, states complete simple thing that all card-carrying members of the APC under a secret open system of election.
Secret open.
Open. So
what happened was
the option A4.
No, they were counting on the field.
Yeah, the option A4 does not comply with the constitution of APC. What complies with the constitution of APC is secret open 6A. There must be a ballot paper.
Secret open ballot.
There must be a ballot paper. There must be a register that can be able to authenticate certain areas.
So somebody can actually go to court.
No, it's simple. It's simple. So, but there are channels of ventilating your
within the party.
Mechanisms. So those internal mechanisms must be exhausted first. It is when
are you doing that?
You have 21 days.
Yeah, you have 14 days. You have 14 days. You have 14 days. Yes. So those ventilation probably might end this week, Thursday coming. That is the upper week. And if the party takes the opportunity to assuage people and be able to address those concerns, then you won't see that explosion. But when the party...
Have you taken steps yourself within this 14 days?
Of course, I petition. I petition on 17th. Petition. So, and there are grants upon which I petition. And those grants are one, there were no registrar provided, there were no return officer, INEC observer were not there in all the centers, And even the returning officer was not published up to the morning of the election. So you could see that there was a gap. And those gaps are grounds upon which anybody can go to court.
What do you think you can do if you...
The most important thing, what was my reason of entering APC? I entered APC from PDP because I believe in the president. And if I believe in the president that I've given one or two issues, infrastructure to my community, I think I should be able to flow with APC. The most important thing is that the president you believe in is strong, bringing up policy that aligns with your people. Election ambition is secondary. But most importantly, I believe that APC National Working Committee will address those petitions. But it opens a window of opportunity for those of them who are probably want to contest.
Who are not assuaged, yes.
We are not assuaged. It opens the gate because what's the essence of oversight? The judiciary oversight the legislative arm and oversight also the executive through their pronouncement. So, and they have done one thing. INEC should adjust their timetable rather than going to appeal. That's my take. INEC should be able to adjust their timetable because their timetable does not align with the act. So I believe that their timetable should be able to align with the act.
And like Amechi said, going to court and getting a court order and people are hanging there, they don't know what to do, it will further complicate the process because we cannot change the time of handover of the election because there are timelines set by the Electoral Act, and we expect that by May 29 next year, there will be a handover. And all the elections must take place except those that are off-cycle elections.
I think adjusting timetable will not affect anything. You are saying that the Electoral Act provided 120 days for submission. So between 120 days and now,
No, what I'm saying is that if INEC goes to court,
there's no need.
If they go to the Court of Appeal and the Court of Appeal reverses or whatever thing they say, it will keep people anxious. Everybody will just be anxious.
Even as of now, the Electoral Act, even if that court did not make pronouncement as of yesterday or the day before yesterday, there was still a window of opportunity for people to cross carpet. The reason being that in other political parties, and you have a situation where all the people who aspire agreed to adopt somebody who have contested election in another party, it becomes a consensus arrangement. Nobody takes you.
I thought the Electoral
Nobody takes you
discourages someone who has participated in
No, it does not. It does not clearly.
From a party
no, it does not clearly.
But was it not shot against them by the membership? No, I'm coming by the membership of the party, the register that was submitted to. And if I were in APC and I lost out, and this judgment has not come, for instance, and my name is with INEC as a member of the APC, and I have not registered with any of the other political party, how could another party adopt me?
Why it won't shut your door is that, you see, when you read comprehensively the entire Electoral Act, you will discover that it didn't hinge on issues of that corporations within a political party if you move. Because the Electoral Act only talked about the primary which you participated. It didn't go extent of talking about the consensus arrangement by other political parties if they agree, because they are the ones to take you to court. It is not the opposing party on pre-election matter.
All right, let's
so there are window of such that the laws has also provided that the National Assembly did not cure completely.
We'll come back to you. You have a last say on our program today, but let's go to our mails where we have those who are listening out there. They send to us their own views, their opinion, and what they think should be the case, or in any case criticize whatever thing that has taken place around citizens' perspective. Political platform at darkgroup.com is the route to reach us. Let's see who is talking to us this morning.
Wada Yahaya from Central Area Abuja says the ruling by the Federal High Court sitting in Abuja yesterday, nullifying the 2027 election timetable issued by INEC, has shown that all hope is not lost yet in the Nigerian judiciary. The court further declared that INEC cannot lawfully abridge or limit the statutory periods provided under the Electoral Act relating to withdrawal and substitution of candidates and so on. Given the above, all those wrongfully manipulated out of the ruling party can be accommodated in other parties to test their popularity and acceptability. Emmanuel Ede from Madala, Niger State, sent in the second one. He says, I'm impressed with the nullification of INEC pre-election guidelines before the 2027 general elections by the Federal High Court, Abuja. More so, I'm appealing to the CSOs, media organizations, NBA, and other well-meaning Nigerians to go to courts to challenge the National Assembly to reconsider and include the immediate electronic transmission of election results in real time that was ignored by it, as this will repose confidence in the citizens in the forthcoming general elections.
Tekena Dagogo in Oyibo City, Rivers State, says congratulating the candidates that have so far emerged in the various party primaries. However, he wants to appeal to INEC to, if possible, make the dates each party submitted their party registers public. We know the deadline INEC set for submission of party registers, and all parties were supposed to have submitted their registers 30 days before the primaries held. And I say so because with the days, we say people defecting to other political parties in Rivers State. I don't want Rivers State people to experience same situation that happened in Zamfara State in 2019, where after voters massively voted for candidates of one party, the Supreme Court said the party didn't comply with the Electoral Act. Also, Rivers.
I think events have overtaken that now with the decision of the court yesterday.
Yes.
Because his anticipation, his fear was that if they start defecting after INEC had taken the decision on the timelines, then there will be a problem. But the window has been opened now. So
yes. The issue of whether you can participate in different party primaries have not been resolved.
Okay.
You know, there was a point that Marcel Egbinine made that we are not looking at. He says a precedent had already been set at the appeal court. And he quoted, sorry, I can't quote that law particularly, but he mentioned that even INEC may not be able to appeal that judgment.
Okay, let me take the last mail from Mokolo Henry, who's writing from Abuja, and he says he's heartbroken over the kidnapping of school pupils and the brutal beheading of a teacher in Oyo State. This is pure wickedness. He's calling on APC-led federal government to stop talking and act now. Rescue those children and punish the killers. No child should be afraid to go to school in Nigeria. He ends by saying, enough is enough.
Yeah, and we want to appreciate you for always keeping it, your time, your pen, and your however you are reaching us through a political platform at thatgroup.com. It makes the program exciting, and we are glad that you are able to share your views with us. Please keep your mails coming, and we'll continue to share them. Now, we'll be wrapping up, and as we wrap up, we still have our guests seated in the studio. We have Honorable Nicholas Osai will stay with us, and we'll be wrapping up with it. Let us hear the very, very last from you on the program. Where do we go from here? How do you expect people to be matured to take these things on an independent National Electoral Commission, the federal government, and the political parties?
To me, my advice to the INEC is there's no need to go to appeal. They should be able to adjust their turntable to align with the Electoral Act. And I also appeal to the All Progressive Congress, where I contested, that the All Progressive Congress in Delta State did not comply with the Constitution,
with the provisions,
the provision of the of APC constitutions. And to me, no returning officers appears in 29 wards out of the 30. So that completely go against the constitution of APC. And secondly, the option A4 that you are seeing the social medias ought not to be, does not align.
But did they also count the way they counted in other, we are seeing they count
that is in only one word.
100, 400?
That's in only one word, but even in that word, non-compliance. So I believe that APC should use this window of opportunity to be able to invite these people if there's any petition.
All right.
And be able to resolve those issues in-house. And so Nigerians, I think, is democracy. That's why you see the court coming to rescue Nigeria. And I believe more court cases will come to challenge the Electoral Act.
Yeah, they are.
All right, which is in conflict completely with the Constitution.
All right, Honorable Nicholas Osai, a former member of the House of Representatives, staying with us from the beginning of the program till the end. We want to appreciate you for your time. And on behalf of my colleagues, Uju Eje, Mustafa Mohammed, and Amechi Anakwe, we want to thank you for staying with us on the program. And when we come back on the other side of the week, we will be having more for you. At least this weekend will be enough for us to digest, chew, and listen to politicians. And those who went for their primaries in their various areas would have come to Abuja, will have opportunity to dissect and take more look. But remember that insecurity is not just a government responsibility. We also have a responsibility to cooperate, provide information. It's not enough to cry and say government is not doing enough. We are doing that already, but we should also make our contributions, applaud the government where they do the correct thing, and make sure that we also do our own part. Thank you for staying with us. My name is Okiria Aponsuremi.